Michigan, sellers of owner-occupied residential property up to 4 units are required by law to complete a seller's disclosure statement when they sell their home. And so a seller's disclosure is required when there is an exchange of real estate, there's a land contract, there's a lease with an option to purchase, or any other option to purchase. So if you're a real estate investor, you need to listen up and know that any lease option requires this disclosure. The disclosure needs to be given to buyers before they execute a binding purchase agreement. Otherwise, a purchaser can cancel the transaction, and without any penalty, they can just walk away from the table up to the time of the closing. And when it comes to the home's condition, there's often confusion on when and what needs to be disclosed by a seller to a prospective buyer. Essentially, the seller must disclose the condition of the property and any other information concerning the property that is known to the seller. And the key word in this whole law and in any actions that I deal with when it comes to seller's disclosure is the word known. Each disclosure required by the Act must be made by the seller in good faith. And the law requires the seller to honestly disclose information known to them at the time of the seller's disclosure statement. So when a seller completes the seller's disclosure statement, they have to be truthful at the time it's completed. Therefore, sellers really don't have a duty to discover defects, but they must use ordinary care when they transmit the disclosure information to the prospective buyer. So sellers are not required to perform any investigation of the property in order to complete the form, and they're not responsible for reporting issues that they should have known, but they did not know. Therefore, a seller, really has not violated the Act where they've, have undisclosed and unknown information, and it could only have been obtained through an inspection or an observation by a professional in areas that are inaccessible of a home, or they could be discovered by a person with expertise beyond the knowledge of the seller. However, what happens if information disclosed becomes inaccurate as a result of some form of event or an occurrence after the purchase agreement's been completed and the disclosure's been already been accepted by the buyer? Well, here's the thing. So long as the inaccuracy was not within the seller's personal knowledge, again, the word knowledge, at the time of the disclosure being completed, the resulting inaccuracy does not constitute a violation of the Michigan Sellers Disclosure Act. Finally, a seller has violated the Act if they've actively concealed or any known information about a true condition of the property. And this is really called fraudulent concealment. And fraud really can allow a buyer to rescind the purchase of a home even after the sale. And the seller is going to be liable to the buyer for all damages related to the seller's non-disclosure. When it comes to fraud, there are no excuses. It's kind of hard to prove, but when you have a case that supports fraud, a purchaser should be able to get their damages. So when you're in doubt, if you need as a seller to disclose a defect in a property's condition, you can discuss the matter first with your real estate agent. However, from my legal perspective, and really simply stated, when you're in doubt, as a seller, always disclose. You'll thank me later. I'm David Sobel, and thanks for watching.